Good evening and welcome to Courts Today by Live Law. This is your host Urvashi Chauhan bringing you the latest updates on the legal front. This is your go-to source for all things legal. Let us start. In a strongly worded critique, the Gujarat High Court today criticized administration of Gujarat National Law University for allegedly concealing accusations brought forth by two students regarding queerphobia and rape on the university premises. A bench of Chief Justice Sunita Agarwal and Justice Aniruddha P. Maye was dealing with the suo motu matter pertaining to rape allegations made by a second-year law student against her batchmate and harassment of a queer student at the GNLU. The court had earlier taken strong exception to the working of the institute's internal fact-finding committee concerned with the issue in question. Describing the sealed cover report submitted by the reconstituted fact-finding committee as scary, the bench asserted that GNLU administration had intentionally withheld crucial information regarding the entirety of the incident. The court empathized with the challenges faced by the students of GNLU in coming forward. It emphasized the importance of upholding the voices of law students who are expected to advocate for justice. The victims claim that a politically influential individual had attempted to suppress the incident before involving the police was noted by the court. The court said that the students would not fabricate their statements, highlighting that they had no apparent personal vendettas. Further, the Advocate General was directed to seek instructions in the matter as to the authority who would be taking action in the case based on the report of the fact-finding committee. In another important update, the Jharkhand High Court today delivered its verdict and dismissed the petition filed by the former State Chief Minister Hemant Soren seeking permission to participate in the budget session of the Assembly, which started on 23rd February. As you know, Soren was arrested last month in connection with a money laundering case linked to an alleged land scam case by the Enforcement Directorate. Senior advocate Kapil Sibal had appeared for Soren, arguing that he should be allowed to participate in the budget session of the State Assembly. On the other hand, additional Solicitor General S.V. Raju, appearing for ED, had contended that Soren did not have a fundamental right to participate in the budget session. A petition has been filed in the Supreme Court challenging demolition of commercial spaces in Lucknow's Akbar Nagar. The occupants of these commercial spaces had initially challenged the LDA's demolition orders in High Court. A division bench of Justice Vivek Chaudhary and Justice Om Prakash Shukla dismissed the petition yesterday, stating that they saw no reason to intervene in favor of the petitioners. The court observed that individuals had misrepresented themselves as slum dwellers and failed to provide accurate information. Upon careful examination of the documents, it became clear that neither the petitioners nor the establishments were situated within the designated slum area. Hence, they have now approached the Supreme Court. This morning, Senior Advocate S. Muralidhar mentioned the matter before a bench led by Justice Sanjeev Khanna. It was argued that following the High Court's order, the LDA wasted no time in commencing the demolition process on last evening, targeting shops and other commercial buildings along Ayodhya Road in Akbar Nagar. However, the court noted that the SLP had not yet been presented to it, so it could not address the matter immediately. Justice Khanna instructed that the petition be first brought before the Registrar General for listing, and once scheduled, the court would address the matter. The Bombay High Court today directed the Housing Minister of Maharashtra government to consider 26/11 Mumbai terror attack victim Devika Rotavan's plea for a residential premises in the economically weaker section. Devika was only 9 years old when the 2008 terror attacks hit Mumbai. She, her father, her brother were at Chhatrapati Shivaji Maharaj Terminus railway station when the gunmen opened fire. She got shot in the leg during the attack and her father and brother got hurt too. Their injuries stopped them from working and Devika could not help either because of her injuries. She told the court that officials from the central and state governments had visited their home after the attacks and promised them a place to live under the economically weaker section quota. This is the second time she has asked the High Court for a home. During the previous hearings, the additional government pleader representing the state government had mentioned that she was already provided with around 13.26 lakhs as compensation on compassionate grounds and that there was no specific state-level scheme in place to address such requests. A division bench of Justices G.S. Kulkarni and Firdosh Puniwala called it a real case to exercise discretion, especially when discretion is often exercised in lesser deserving cases. The bench was also displeased by the Secretary of the Housing Department's mechanical response, stating that such a request could not be entertained without the filing of an affidavit in the matter. The Delhi High Court has ruled that Section 37 of Narcotic Drugs and Psychotropic Substances Act of 1985 does not prevent a court from granting bail to an accused person due to a delay in completing the trial. For your information, Section 37 says that a person accused under the NDPS Act can only get bail if two conditions are met. First, there is reasonable ground to believe that he is not guilty of the crime, and second, that it is unlikely that he will commit another crime if released on bail. Justice Naveen Chawla stated that long periods of being in jail often go against the right to life and freedom promised under Article 21. Therefore, granting conditional freedom should be prioritized over the legal restriction mentioned under Section 37. With this decision, the court granted bail to two accused persons charged under the NDPS Act. The accusation against them was that 6 brown-colored packets containing a substance similar to cannabis was found in their possession. The Supreme Court has held that once the magistrate has called for the police report under Section 202 of CRPC, then the magistrate cannot issue a summons unless the report is submitted by the police. This provision allows a judge to delay taking action against someone accused of a crime if they believe more investigation is needed before making a decision. The judge can either investigate the case themselves or ask the police or another person to look into it further. This is done to make sure that there is enough evidence to proceed with legal action. In this case, reversing the decision of the High Court, which had refused to quash the summons issued by the magistrate, the Supreme Court bench of Justices Abhay S. Oak and Ujjal Bhuya has observed that the magistrate cannot issue process to the accused without application of mind and ought to have waited to issue process against the accused until the report was received from the police. The court also noted that an order issuing process of summon against the accused has drastic consequences and hence should not be issued without an application of mind. And lastly, the Supreme Court has observed that wife's suicide within 7 years of marriage will not raise presumption of husband's abetment if there is no evidence of cruelty. In this case, the appellant husband got married in 1992. A year later, the wife died by suicide after consuming poison. The husband was accused of harassing her for money, leading her to suicide, and was charged for abetment of suicide. He was convicted by the trial court in the year 1998. Further, the Punjab and Haryana High Court dismissed his appeal in 2008. Subsequently, he approached the Supreme Court. The appellant's counsel argued that there was no evidence to suggest that he harassed the deceased. The state's counsel countered by highlighting that the wife died within 7 years of marriage, implying a potential connection to the appellant's behavior. After going through the testimonies of deceased's brother and father, the court observed that what drove her to end her life was not clear. It held that mere demand of money from the deceased or her parents without anything more did not constitute cruelty or harassment. Summarizing the legal stance on abetment of suicide, the court referenced several past cases. It was established that to establish abetment, there must be evidence of instigation, conspiracy, or intentional aid by the accused. Additionally, there must be evidence of a deliberate action by the accused to encourage or assist someone in committing suicide. Thank you for watching. If you wish to know more details about the cases I mentioned here, you can visit our website at www.livelaw.in. Stay ahead with quick legal updates only on Live Law. Do not forget to like, share and subscribe and support us. You can also support us by donating through the thanks button at the bottom of our videos or consider becoming a member at just 89 rupees per month.